So, thank you very much for the very nice introduction. It is a great pleasure to be able to speak to you today about the institutional guarantees of judicial independence in Austria. Some of the things I will talk about to you are probably nothing new to you. We have classical guarantees of judges being independent, irremovable from office, etc. And the second part I will focus on is more of a special topic from Austria concerning case distribution. As we see, this might come as maybe news to some of you in a maybe special Austrian way of securing judicial independence overall. So, the Austrian legal system contains several provisions which aim at securing judicial independence. For example, Article 6 of the European Convention on Human Rights, which, like the convention as a whole, has the rank of a federal constitutional law in Austria, which is an Austrian specialty, is a central fundamental right which guarantees, amongst other things, the independence and impartiality of courts. And Austrian courts are also bound by Article 47 of the Charter of Fundamental Rights of the European Union, which largely lays down the same guarantees as Article 6 concerning judicial independence. But these guarantees of fair trial are nothing new to you. They're common to all legal systems, which we are going to hear about today. So I'm not going to go further into detail of these. What I want to focus on is the guarantees of independence, which are specific to the Austrian Constitution. As I already mentioned at the beginning, the Austrian Federal Constitution, that is the Bundesverfassungsgesetz, broadly speaking, contains two categories of guarantees that aim at safeguarding judicial independence. This is on the one hand the specific judicial guarantees, so judges are independent, irremovable from office, and intransferable. And on the other hand, as I said, of particular importance to Austria when compared to many other legal systems, there are constitutional guarantees concerning the handling and allocation of cases amongst courts as well as amongst judges, which also aim at securing the independence of the judiciary ultimately. That's the right to one's lawful judge and the principle of established distribution of cases. And as I will also show, the institutions of judicial self-governance in Austria are much less pronounced than in many other states, especially the states that followed the recommendations or expectations of the Venice Commission in this field. So especially the appointment of judges, which I will also come back to, is, according to the Constitution, a largely political process which is handed to the executive and not to judicial self-governance. I will start with the judicial guarantees of independence, irremovability, and intransferability. I want to stress one point here at the beginning. In contrast to Article 6 of the Convention, these are purely institutional guarantees, protecting judges in the exercise of their judicial office and not subjective fundamental rights that may be invoked by individuals. But of course, they are not means in themselves and not ends to themselves. Their purpose is ultimately to protect individuals and their rights in court proceedings. The guarantee of independence of judges, as laid down in Article 87 of the Federal Constitution, safeguards that only the law in form of general legal rules shall be applied to a case by judges. Judges have to disregard directives and other attempts to take influence on the exercise of their office, be it from administrative authorities or from other state bodies, also from within the judiciary. Such acts, which try to take influence, are unlawful by Constitution. And this not only concerns individual or general administrative directives, but also any other legal acts or any other form of pressure attempting to bind judges to a certain legal opinion. As I said, besides legal acts, also other conduct from state organs that in effect exerts pressure on judges is unlawful. For example, if the head of a court applies soft pressure on a judge to decide a case in a certain way, or if he threatens to take disciplinary measures against a judge, this may be deemed to infringe upon a judge's independence. One has to bear in mind, though, that judges are regularly under pressure from different sides, be it from the media or from the public in high-profile cases, or be it from parties to the proceedings, from colleagues, or from supervisory bodies. The law expects judges to show, amongst other things, a character appropriate for their office, especially the ability to withstand most forms of soft pressure. Thus, not every conduct that may be deemed in some form as pressure, or putting pressure on a judge, can be deemed to also infringe upon a judge's independence. The Supreme Court of Justice of Austria has found in this context that the adoption or the threat of disciplinary measures against a judge in a case where the judge held a different but still justifiable legal opinion than the president of the court in question, that this, and if the president threatened disciplinary measures in this case, that this was incompatible with judicial independence. Also, financial measures, for example, in the form of grave salary cuts, without objective reasons, may infringe upon a judge's constitutional independence. The constitutional guarantee of independence also comprises the inner independence of a judge, so judges are to act impartially and objectively. However, as I said, this is not a fundamental right of the parties. It is only through statutory and sub-constitutional law that the parties have a right to an impartial judge in Austria, if we leave Article 6 of the Convention out of the picture. The guarantees of irremovability and intransferability, according to Article 88 of the Federal Constitution, serve two major purposes. On the one hand, they safeguard the personal independence of the judge, so the judges don't have to fear to be removed from their office if they decide only on the basis of the law. On the other hand, from the perspective of the individuals and parties to proceedings, the provision guarantees that a judge may not be arbitrarily replaced by a judge which may seem more suitable to decide a certain case from a political point of view. This guarantee of irremovability stipulates that that a judge may not be removed from office unless a case explicitly provided for by law occurs and the removal is enacted through a formal judicial ruling. Only in drastic and grave cases may statutory law allow for removal. And also, the legislator may not by itself remove judges. There is always a judicial body to be involved that is only composed of judges. The guarantee of intransferability, which I will just want to briefly mention, guarantees the same not for removal from office, but for transfer to another court. It is only permissible if prescribed by law and if it is decided by a judicial ruling through a judicial body. Last point in this context, the appointment of judges, which of course is not in itself in the first hand the guarantee of independence. It is still closely connected to independence of judges, of course, because the appointment is the very first point in time where administrative bodies, the judiciary, or whoever might take influence on the judiciary through choosing the right candidate, which seems politically right for the place or for this office. In Austria, as I mentioned, the appointment of judges lies in the hands of the executive. In contrast to some other countries, it is not entrusted to judicial self-governance. The influence of the judiciary is limited to unbinding or non-binding proposals to the executive. Judges of the courts of justice are appointed by the federal president or, which is factually the case, by the minister of justice upon authorization by the president. Before appointing judges, proposals of at least 3 candidates shall be obtained from judicial chambers. However, as I said, the president or the minister are not bound by these proposals. President and minister are free to appoint other candidates as long as they meet the relevant qualification criteria. So effectively, the judiciary, from a legal point of view in Austria, has only an advisory function in the appointment of judges. In practice, the president and the minister up to now have always followed the proposals by judicial chambers. This strong position of the executive in the appointment procedures of judges has, of course, been criticized from some sides, especially from within the judiciary in Austria. However, I have to stress that these voices are not overly loud, so it seems that we're still somehow satisfied with this way of appointment. But it obviously leaves room for political influence if a president or a minister has malevolent intentions to take influence on the judiciary. Until now, office holders of president and of the minister took their responsibility for the functioning of the judiciary and for the state as a whole seriously. However, this does not mean that this will hold true in the future, especially when we see the strengthening of extreme political powers. But why does the Austrian constitution give such a strong position to the president or the Minister of Justice? The reason is that the constitution attributes crucial importance to the democratic legitimacy of judges and the judiciary as a whole. The executive organs involved in this process, the President and the Minister of Justice, are either directly elected by the people or democratically legitimized through Parliament. So the appointment of judges through judicial self-governance lacks such a high degree of democratic legitimacy, one might say. In my opinion, the question in the end remains which of the two safeguards judicial legitimacy better while still ensuring democratic connections. It seems to me that ultimately this depends on the people taking part in these proceedings and on the spirit of the judges who are to be appointed, and less on the legal rules and the legal appointment procedures. But this is a topic for the discussion later on, maybe. I come now to the second part, which might be more of news to you from a organizational point of view. As I already said, beside these institutional guarantees, the Austrian constitution specifically safeguards judicial independence through rules on the distribution of cases. That is, the fundamental right to one's lawful judge and the principle of established distribution of cases. The rationale behind these rules is that the independence of the judiciary with respect to the individual's case at hand could be compromised by acts through which the jurisdiction of a court or of a judge is arbitrarily changed. For example, if authorities were free to choose a judge for a certain case that for political reasons seems more suitable for the case and could pass a more favorable judgment. Thus, the right to one's lawful judge and the principle of established distribution of cases, in essence, require that an individual's case must be decided by a court and judge or senate, the jurisdiction of which is objectively and precisely determined in advance by law. The fundamental right to one's lawful judge guarantees the compliance with the statutory competences of the courts and their various formations. The right is violated if a decision is not passed by the court that, according to statutory law, has jurisdiction ratione loci and ratione materiae for the case in question. The right is further infringed upon if the competent court decides, but in a formation that is not in accordance with the law, for example, if a single judge decides instead of a judicial panel. A noteworthy point in this context that I will come back to, and that is maybe even more special to the Austrian constitution when compared to the system of Article 6 and fair trial guarantees of the convention, is that the right to one's lawful judge follows a strictly formal approach. Every violation of statutory rules of jurisdiction of a court amounts to a violation of the fundamental right, irrespective of how severe this violation may be from the individual's perspective or whether there is any real risk of arbitrariness in the decision-making. I will come back to this shortly after the distribution of cases. The right to one's lawful judge that I mentioned is substantiated further through the principle of established distribution of cases. Together, these provisions grant another fundamental right, that is the right to one's judge in accordance with the case distribution of a court. For example, that is the right, firstly, to one's court in the right formation, and then the right that the decision is rendered by a judge named in the case distribution, specifically named. I will explain in detail now. Yeah? This principle of established distribution of cases, which is also known in Germany in this strict sense, but not in many other legal order, is a specific feature of the organization of the Austrian judiciary. While also other court systems, of course, know some case distribution rules, and also the European Court of Justice's system knows some case distribution rules, they are by far not as strict as the Austrian constitution demands for. In this, the principle of established distribution of cases also follows a strictly formal approach. The case distribution is to be determined in such a way that the individual in advance can identify which judge or panel will be competent to decide her or his case. It has to define the names of the competent judges and the substitute in cases of hindrance. The case distribution has to determine the competence of a judges through precise, objective, and rigid criteria so that do not leave any margin of appreciation or discretion for arbitrary influence on case distribution from any side. The allocation must follow directly and automatically from the defined criteria so that no act from any person or body is necessary to assign a case to a certain judge. Possible criteria in this context might be a distribution by subject matters, first letters of the last name, names of the applicants, residency, or by time period. In practice, at the most courts, the case distribution follows a rotation principle. So the cases are assigned going around in a circle following the order in which applications arrive at the court. The Austrian Supreme Court of Justice deems this method of appointment to be permissible as long as it is ensured that no influence on the case distribution is possible. However, this method still may leave some room for arbitrariness at the time where the order of arrival at cases at the court is determined. And also, the individual may in no way in advance know her or his judge in advance. So large parts of legal scholarship, including me, to out myself here, does see this method of appointment incompatible with the principle of established distribution of cases. A further prerequisite for the distribution of cases is that it is to be enacted in advance, so that the case that comes into a court finds a distribution that is already in force when the case comes to the court. In practice, this period is 1 year. And changes to the case distribution and withdrawal of cases from a judge are only permissible under specific and rigid circumstances. In any case, these changes have to be enacted as general rules. Individual dispositions are prohibited. As an exception to the rule that I mentioned at the beginning, that judicial self-governance is not so important in Austria, the established distribution of cases is a matter of judicial self-governance. It is to be enacted by judge panels at each court, which are composed only of judges. And as I said, every breach of this distribution of cases renders a case illegal and unlawful. That is, if a case is assigned to a judge not competent for the case, or to a panel of judges where the judges are not competent. The point that I have already briefly addressed and that I want to highlight here is that the Austrian Constitution for safeguarding judicial independence in this context, with the right to one's lawful judge and the established distribution of cases, follows a specifically formal approach. As I said, any breach of the rules on court competences and the judge's competences are automatically unlawful, irrespective of how grave such an infraction might be and whether there are any indications pointing towards arbitrariness. In contrast to this, many constitutions, and especially Article 6 of the European Convention of Human Rights, follow a substantive or more material approach. A decision only violates Article 6 of the Convention if the errors in jurisdiction or the assignment of cases show signs of arbitrariness or bias. According to the case law of the European Court of Human Rights, even if clear rules on case distribution and court jurisdiction are broken, Article 6 is only violated if there are signs of arbitrariness. Also, in contrast to the Austrian system, Article 6 of the Convention tolerates case distribution systems which are much less strict. For example, where a court's president can assign each case brought to a court individually, as long as this is practiced objectively and impartially. The Austrian system in this context excludes any concerns concerning real arbitrariness. Every breach is automatically deemed as arbitrary and thus impermissible. At the same time, from a constitutional point of view and in comparison to other systems, other factors are deemed less important for the Austrian constitutional system. For example, questions of judicial bias and partiality are not regulated as strictly on a constitutional level. If we leave, as I said, Article 6 out of the picture, they are regulated only on a sub-constitutional statutory law level. Interestingly, and that's my final point before I come to the conclusion, on the level of legal remedies, for example, in criminal proceedings, the Supreme Court of Austria does follow a more substantive or material approach. In contrast to what I have said on the right to one's lawful judge and the established distribution of cases, grounds for annulment, according to the case law of the Supreme Court, are only there if the breach of the distribution of cases shows unfairness in the sense of Article 6. From a constitutional point of view, this can be criticized. The Austrian Constitutional Court has a different point of view concerning the administrative courts. He follows the system that I have mentioned, that every breach of these rules also violates the constitutional system. I thus come finally to my conclusions. As I have discussed, besides Article 6 of the Conventions, there are two main pillars of institutional guarantees of judicial independence in Austria. That is the judicial guarantees of independence and irremovability and intransferability, and the case distribution system that I have mentioned. Institutions of judicial self-governance are not strongly pronounced, especially the appointment of judges is left to the executive, that is the federal president and the Minister of Justice. The Austrian constitution here puts democratic legitimacy above most other considerations. And in the end, the question remains, of course, which system functions better, judicial self-governance or appointment by the executive. I've already mentioned that for me, I think the major point or the most important point is how the rules are lived. If the executive or other bodies want to take influence on the judiciary, they can do so under most legal systems. If people involved in the whole system respect the whole system, and that means people appointing judges and judges being self-conscious and knowing about their role that they should take in the state, then I think judicial independence is safeguarded and safe factually. Thank you very much.